Welcome to One Brothas Mind, and I am KD Smooth. Today we will question and challenge popular information and views from a B1 perspective, while we expose the real facts you need. We do this to strengthen your logical, critical, and discerning thinking skills. Because in today's world, hard choices are mandatory and they come with consequences. So you need all the information. And at One Brothas Mind, we do this from a B1 Yeshua the Christ follower's perspective. Now, if you're not ready, you better get ready with KD Smooth at One Brothas Mind. Welcome, ladies and gentlemen. It's KD Smooth coming back at you with a new report. Today's report, family, is we're going to be covering this new ruling from the Supreme Court, specifically the ruling where the Supreme Court just ruled that evidence of innocence is not enough to overturn convictions. Yeah, you heard it right. The Supreme Court just ruled that the evidence of innocence is not enough to overturn convictions. This ruling, family, was headed by Clarence Thomas. That's who led this ruling, family. So, yeah, we're going to dig into this here. But just before we dig in, I got a couple of I got something I got to get off my chest about the people. Actually, this ruling was ruled in a 6-3 ruling. So to the 6, including Clarence Thomas, you mother son of a need to be okay. I just had to get that out, family. I'm sorry. This is Satan, y'all. This is Satan. No which way how you slice it. This is Satan, y'all. Okay. Let's dig into this here. Again, this is a report that the U.S. Supreme Court just said that evidence of innocence is not enough to overturn convictions. I'm going to be sharing with you briefly here today a report from Yahoo News. The writer of this report is Michael A. Cohen. This was released on May 23rd, 2022. Okay, family? Yeah. All right, let's dig in. I'm going to actually read a couple of highlights here from this report. That's what I'm going to do. I'm going to read a couple of highlights here. And we're going to... Wow. I can't even talk. Yeah. Okay. According to this report from Yahoo News, Michael Cohen is the writer, on May 23rd, 2022, it reads, last December, the Supreme Court gathered to hear oral arguments in Shin versus Ramirez, a case that could mean life or death for Barry Jones, who sits on death row in Arizona for the rape and murder of his girlfriend's 4-year-old daughter, Rachel. In 2018, a federal court overturned Jones's conviction, concluding that he had failed to receive effective counsel, a violation of his Sixth Amendment rights. Had that happened, a federal judge ruled there is reasonable probability that his jury would have not convicted him of any crimes with which he was charged and previously convicted. In other words, if he had received adequate representation from his lawyers, the jury would have not convicted him of any of the crimes in which he was charged and convicted. Okay? Now, after this loss in the Ninth U.S. Circuit Court of Appeals, Arizona's Attorney General appealed this judge's decision to the Supreme Court. During those oral arguments, state prosecutors repeatedly argued that innocence isn't enough of a reason to throw out Mr. Jones's conviction. I'm going to say that again, family. The Arizona Attorney General repeatedly argued to the Supreme Court that innocence isn't enough of a reason to throw out Mr. Jones's conviction. And on Monday morning, by a 6-3 vote, the Supreme Court concurred that Barry Jones's innocence is not enough to keep him off of death row. The state of Arizona can kill Mr. Jones, can murder him, even if there exists a preponderance of evidence that he committed no crime. One more time for those in the back seat. In a 6-3 vote, the Supreme Court concurred that Barry Jones's innocence is not enough to keep him off of death row or overturn his convictions. The state of Arizona can still murder Mr. Jones even if there exists a preponderance of evidence that he committed no crime. The crime for which Jones was convicted is horrific. The little girl, Rachel, died from the result of a rupture in her small intestine that the state of Arizona claimed came from repeated physical and sexual abuse. But Jones's lawyers never questioned the physical evidence that led to his conviction. I'm going to mess this lady's name up, so y'all forgive me. As Lelena Segria, an investigative reporter for The Intercept, pointed out last year, had Jones's lawyers been up to the task, had they did their job correctly, at least reasonably, there was plenty they could have done to defend their client. They could have pointed out that the lead detective who examined the little girl Rachel at the hospital didn't bother to investigate how or when the child sustained her fatal injury. Or they didn't consider a single other suspect aside from Jones. They could have called a medical expert to show that there was no real evidence that the child had been raped. And most critically, Jones's lawyers could have called a pathologist to challenge the state's theory of the crime, which rested on a narrow time frame during which Jones had supposedly assaulted the little girl Rachel the day before her death. Medical experts now say that the little girl Rachel's abdominal injury could not have become fatal so quickly, or fatal within one day. At the time of his trial, Mr. Jones was appointed a lawyer, public defender, y'all, by the state. A fundamental constitutional right guaranteed to all criminal defendants under the Sixth Amendment. If a defendant argues after conviction that they failed to receive adequate counsel, they are appointed new legal representation. If the new lawyer also provides ineffective counsel, a federal habeas appeal allows them to argue that their post-conviction lawyer, the second lawyer, was ineffective. In effect, Jones argued that he received ineffective counsel not once, but twice. And the fault lies not with him, but rather with his lawyers who were appointed by the state of Arizona. By allowing him to introduce evidence of his innocence, a federal court would be, in effect, rectifying the mistakes made not just by his lawyers, but by the state responsible for appointing them. A little further on, it reads, in the Supreme Court's decision, which was written by Clarence Thomas, the court ruled that a federal court may not conduct an evidentiary hearing or otherwise consider evidence beyond the state court record based on the ineffective assistance of state post-conviction counsel. In short, a convicted defendant like Jones can be held responsible and kept in prison if his state-appointed lawyer provided ineffective counsel for his appeal. How can a defendant argue ineffective counsel if they can't point to specific examples of that ineffective counsel? Or how else can they do that other than by introducing new evidence not presented at trial, which would have likely acquitted them? Thomas is saying, in effect, that a petitioner has to rely on the record of the trial in which they were ineffectively defended, and their actual innocence is of secondary importance. In other words, they can only use what's on the record from the first two jacked up trials where they were not represented by their lawyers, their court-appointed lawyers, properly or reasonably. They're still stuck with that. They can't show and list the reasons why their court-appointed lawyers did not represent them reasonably or effectively. That's not admissible. That's what Clarence Thomas is saying. Even though when you demonstrate and show where those lawyers didn't do their job, didn't represent you reasonably, that caused your conviction. Clarence Thomas is saying, nah, we that don't count. Thomas justifies the court's decision by arguing that a federal review imposes significant costs on state criminal justice systems. That includes potentially overriding the state's sovereign power to enforce societal norms through criminal law. Did y'all hear that? So he's basically saying because it's going to cost the state to review what the state representatives or these jackleg court-appointed lawyers are doing, or better phrase, are not doing when they're representing people, that cost is the reason for these reviews not to happen. Even though these reviews can and often do show and prove that the court-appointed lawyers did not do their job. They did not provide reasonable defense to their clients, therefore leading to their clients' convictions. One opinion of this ruling says, housing a man who committed no actual crime on Arizona's death row imposes significant costs also. Clarence, you talk about the cost to the state. Well, you got innocent people in jail due to jackleg attorneys and jackleg defenses. There's a cost to that too. Okay? Also, executing an innocent man imposes far greater societal costs, not just to the legitimacy of the criminal justice system, but more accurately to the man whose life the state ends, or who the state is murdering that was innocent. But again, just to be clear, Clarence is arguing in this actual rule. This is the actual rule, y'all. This is new case law. This is the new guidelines. He's saying, if we allow this review process to go forward, every prisoner can just file a new motion to say they were denied effective assistance or effective representation. So do we as a society want to pay the cost, the money, to make sure innocent people don't get killed? This is literally what Clarence Thomas said. Not for these guys. So you basically say, so much for the right to life, right? Family? Let me say this before I dig in even more. The article goes on further to say, simple logic would suggest that proving one's innocence is enough to ensure that a wrongful conviction is overturned and an innocent man or woman is set free. Not to Clarence and 5 other members of our current Supreme Court. Okay. Woo, y'all. Be clear. Be clear, family. Be clear. His court-appointed lawyers, in this case, Mr. Jones' case, basically, if they did the bare minimum, they only did the bare minimum in his representation. As you heard earlier in the article, there was 2 or 3 other things, significant things that his attorneys could have presented during his trial that most likely would have led to a non-conviction. Proof that he did not commit the crime. Especially the evidence that showed that the doctors are saying there's no way this child could have sustained this injury from what you guys are suggesting as physical abuse and rape, and then actually died from these injuries the following day. These injuries take longer to fully manifest, is what they were saying, to cause that severe of an injury that causes death. There's no way. The doctors are saying there's no way. Even if what you say happened, there's no way medically it would have caused this child's death the next day. Therefore, this child sustained these injuries prior to when this child was in the presence of Mr. Jones. That alone proves his innocence, family. Okay? But his attorneys, his court-appointed lawyers didn't argue that or any of the other things that were mentioned earlier in this article. But that's not enough for the Supreme Court. We ain't got to review this. It doesn't matter if he's innocent, according to Clarence and his boys. And again, y'all, Clarence is like, hey, if we rule in the opposite of how we are ruling this, or how I'm ruling this, me and my boys, anybody and everybody that's in jail can just file an appeal claim and say they received jacked up, horrible representation during their trials, and ask for, at the very least, a retrial or a review to prove they're innocent. Anybody can do that. That's gonna cost a lot of money, y'all. This is Clarence. He worried about the cost, the actual money cost to the state. Family. Again, as the article clearly set out, there's a cost for actually keeping innocent people in jail too every day. But guess what, family? Remember, they make money off of inmates. In the U.S., that's where you find still legalized slavery that they make money off of. They have no real incentive. Or let me say this, innocence is not an incentive for them to release their slaves. Be clear on what's happening here, family. Again, even when there's clear proof, the lawyers didn't include major or multiple things in your defense to prove your innocence. That's not enough to give you a retrial or overturn your conviction or get you off death row in this case. So basically, what they're saying is, and what you have to understand is, when you are a court-appointed lawyer, most of them are inexperienced, and in the U.S. family, most of them are white, and many of them are racist. So they're not motivated. They're also, in their defense, their caseloads are crazy high. They don't have enough time and resources to really put together a quality defense for people that they get appointed to. That's in their defense. But instead of saying, let's make sure in the cases that have proof, we review them and make sure we're not keeping innocent people in jail or sending innocent people to death row. Let's review. No, they won't do that. Like I said, they don't want to release their slaves that they make money off of. In other words, There's no oversight for satanic bad defense. So family, who's to say that many of these so-called public defenders aren't doing this bad, so-called jacked up bad defense on purpose? Especially if they know there's not going to be any review or oversight of their jacked up, potentially on purpose bad defense, right? So ask yourself, family, who mostly in the U.S. gets bad defenses from court-appointed lawyers? Yeah. Black people and the poor. Okay? I'm sorry if I apologize again for the my little the little censor tone at the beginning. I had to spit it out, family. I had to get out my system just to be able to get into this report. Nah, bruh. So, real quick, what's the solutions that we have, family? It's not hardly any. But one, do everything we can, family, to make sure that we are facing charges of any kind. As far as criminal charges, we got to do everything we can to not have public defenders, to try to have our own lawyers and try to have the best or hire the best experienced, knowledgeable lawyers that we can have that will put on the right defense, or at least a good enough defense, reasonable defense for us, family. Because you got a whole bunch of lawyers out there, they just make money. They don't really care. And oftentimes, to put on a full defense, the lawyers actually have to do a significant amount of research and work. And many of them, y'all, they don't want to do that. They literally just want to do the lazy route, do the easy stuff, and then go, well, I did the best I could, and walk away. While you now spend years or the rest of your life in jail, or actually end up on death row. They don't care. Okay? So family, y'all better really let this stuff sink in. Prepare yourselves and make plans to fight. To be ready for these kind of fights, because they're getting ready to happen more and more often. Maybe to you. Maybe to one of your family members. Okay? Be clear, family. This country, the U.S., their courts, judges, government, the police, their schools, their healthcare system, and most of the corporations, they practice systematic white supremacy and are pure evil. They are Satan incarnate. Family, we have to always be prepared to defend ourselves and our lives and the lives of our family, even up to the ultimate cost. And just as Professor Black Truth says, family, always be sure to have your power tools with you, because you never know when you're going to have to put in some work. that's it. Just real quick, family. Please remember to like, share, and subscribe to One Brothas Mind, because we try to provide you with the information and facts you need. Okay? And make sure you turn on all notifications so you get the alert when we go live and when we post new content. But y'all let me know what you think about this. If you have some other solution options, please share them in the comments. Let's chop it up in the comments on this. Your boy Clarence and them, they beyond clowning, y'all. And they just getting started. Hello? Are y'all hearing this? They just getting started, family. And this concludes this broadcast for One Brothas Mind. We thank you for joining us. And as a part of the new Black media, B1 choices are mandatory and being on code is required. But never fear. Yeshua the Christ is with you always. Shalom.